Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Welcome. Today's topic. I received a question and I thought it was a good idea to answer it on this video. The question was, does a trust need to be probated? That's the question. Before I get to the question, if you would like to make an appointment to ask me your questions, go to frankbrunolaw.com. So the answer to the question is no. A trust does not have to be probated. And the reason for that is that a trust is a will substitute, and when properly funded, the trust owns the assets at the death of the person, and therefore probate is avoided. So if I have a house and I form a trust, so I have a trust and a house, just using this as an example, and say one bank account. That's the example. A trust, a living trust, I'm going to use that term, a house and a bank account. If I properly fund it, and what funding is, I take the property and I retitle it. So if it's a deed, if it's a property, you need a new deed, and the deed has to be retitled, a new deed filed in the county registrar's office where you have the deed. And then the trust, so the trust of Frank Bruno would now own that piece of property. And upon my death, that property would not need to be the trust would not need to be probated. There would be no need for a probate with respect to the property because the trust already owned it while I was alive. And the bank account. So if I have any sum of money, $2,000 in a TD savings account, and if in my example I own it as Frank Bruno, well, I have to retitle that TD bank into the name of the trust of Frank Bruno. And it's retitled. They take those steps in that process with the bank. And therefore, my trust owns a house and the bank account, and there is no need for probate. So a trust does not need to be probate. If you would like to discuss issues related to a trust, elder law, senior issues, and probate, please reach out to me, frankbrunolaw.com.